Assalamualaikum and hi everyone.
We are from Group 4 and we'll be presenting to you about the types of consideration, which is consideration need not benefit the promisor.
In contract law, consideration is one of the elements that plays an important role to form a valid contract. Based on legal terms, consideration can be defined as something of value exchange between parties in the contract. Hence, there are 5 flows of consideration and one of it is consideration need not benefit the promisor. The development of contract law recognizes that consideration does not need to be tied to direct financial or material benefit for the promisor. There can be consideration where the promisor suffers some detriment at the request of the promisor but gives no benefit to the promisor. In other words, promisor did not directly need to give any benefit or value in consideration. This type of consideration allows for different types of contractual relationships and recognizes that value can be subjective and be given in various ways. For example, the case to illustrate this type of consideration is Wat and Barham case.
After the separation of the unmarried couple, she, the mother, became a housekeeper to a man who was ready to let her to have the child. She wrote asking to the father to let her have a child and pay £1 a week.
To Mr. Bayham, the purpose of me writing this letter is to ask for your permission to let me look after our daughter, and for that, you will pay me £1 a week like how you pay your neighbor to look for our daughter. Sincerely, your ex-wife.
The mother received a letter from the father that saying, I am prepared to let you to have the child and will pay for you up to £1 a week for providing, and you have to prove that she will be looked after and happy, and she is allowed to decide for herself whether or not she wishes to come and live with you. She received £1 a week.
I agree with you. I will let you have the child. But you need to promise me one thing. You need to make sure the child happy living with you. If you can make the promise, I will provide you allowance £1 a week.
7 months later, she married to the man for whom she acting to be housekeeper. The father then stopped the payment.
How are you doing?
I'm good.
Well, someone told me that you are married and a man.
Yes, I'm married right now.
Fine. Since you're married right now, I will start providing you £1 a week.
No, you cannot do that. I have provided everything for our daughter. She lives happily with me.
I don't care what you say. I will stop providing.
Fine, I will bring this matter to court. See you there. I will make sure I will.
After thorough examination of the facts, the court recognized that the mother's performance of taking care of the child in a way that made the child happy, in accordance with the agreement, was valid consideration, even though the benefit was not directly to the father.
The Court of Appeal held that notwithstanding the mother's statutory duty to maintain the child, the mother's looking after the child in accordance with the agreement with the father was sufficient consideration for his promise to pay. Thus, the father was liable to make the payment under the agreement.
Wat and Barham is a crucial case in contract law, highlighted the rule of consideration, which consideration need not benefit the promisor. In this case, the court recognized that the mother's conduct in providing a home for her child and carrying the child in a way that made her happy was a valid consideration, even though it did not directly benefit the promisor, which is the father, Mr. Barham. This case showed that what counts as consideration or something value in the contract can be broader than just benefiting the promisor. Instead, indirectly the benefit the promisor can indeed fulfill the requirements of a valid contract. The second case is Johns and Paravatan case.
The claimant was the defendant's mother, had made a deal with the defendant, specified that the defendant would give up her employment in the US and move to England with her family to read for the bar.
My mom called.
Hi! Hello daughter, how are you?
Hi mom. Yeah, what do you want? I want you to move to England with me and I'll pay you £42 a month. In exchange, the claimant would provide her £42 a month and the pair later agreed that the claimant would also provide a house for the defendants to live in.
Okay, but I want you to provide me a house because I don't want to live with you.
Okay, then I will provide you a house too. See you then. Bye.
Okay, bye.
The parties' relationship soared over the fact that the defendant had not finished her studies in 5 years. The claimant sought possession of the house, but the defendant urged to stay and said that she was still entitled to get £42 a month. This was because she claimed that there has been a contract made between them. However, the mother said that she has no intention to be legally bound, therefore no contract was made.
As you don't finish your studies, I will take back the house.
No, I want to stay in this house and you must pay £42 for me like every month.
No, I am the mother, so I will make the decision.
Plus, we already had an agreement about this.
I have no intention to be legally bound by it.
The court of appeal held in favor of the claimant. They parties were presumed not to have intended to be legally bound. The defendant also not provided sufficient evidence to rebut this presumption. Therefore, defendant had no right to the £42 and no defense against the possession claim.
After careful consideration of the evidence presented, the court declares that the contract is null and void because there is no intention to create a legal relation between the mother and the daughter.
The court held there was no binding contract. The court applied the presumption that agreement between family members, especially in domestic settings, are presumed not to be legally binding unless there is clear evidence of intention to create legal relations. In this case, the court found insufficient evidence to rebut this presumption. Other than that, the court also noted that even if there had been contract, it would be lasted until the daughter passed her bar final. However, since 5 years had passed and she did not yet completed her exam, the court held that the contract had elapsed.
And Derivative is a significant family law case highlighting the delicate between the familial commitment and a legal enforceability. The mother supported her daughter financially during her studies with an informal agreement for repayment upon her financial independence. The case revolves around the absence of a clear intention to create a legally binding contract, reaffirming the long-standing presumption that family agreements are not inherently legally binding. This reflects the court recognition of a unique nature of familial relationship, prioritizing the trust, love, and shared responsibility over a formal contract obligation. In a sense, Jones and Pedavaton exemplifies the court understanding that not all promises within a family are enforceable in a legal context.
I would like to conclude this video. In a nutshell, these two cases reflect a family relationship and the need for legal support. Both divisions contribute to a further understanding of promises made by the family members, promoting fairness and equity in the principle of contract arrangement. Number 2, the legal principle is conversion not need benefit the promisor. This legal principle is a fundamental principle in a contract arrangements. We all know that if you want to make a contract to be valid, there must be a conciliation exchange between the parties. But we need to understand that the benefit for the promisor is not a strict requirement. That's the end of our video. Thank you for watching. Bye bye.